You're listening to Kerry Lutz's Financial Survival Network, where you get valuable information you just can't find anywhere else. To thrive in today's trying times, you need the Financial Survival Network, now more than ever. Go to financialsurvivalnetwork.com and get your free newsletter and gift. Financial Survival Network, now more than ever.
Welcome. You are listening to the Financial Survival Network. I'm Kerry Lutz. Today is 2/17/2021. Well, if you're like many millennials and boomers too, it's probably not something you think about much or you want to think about much. I'm talking about estate planning. But with the advent of the COVID epidemic and its effects being felt throughout the world, throughout society, more and more of you are thinking about it now, as am I. As you might know, I had a bout of COVID, and the first thing I'm thinking about, especially as an attorney, is, oh my goodness, I am leaving my kids a complete mess. And it's not like I didn't have anything to leave them. I did have some stuff, not as much as I'd like, but enough so that they would wind up spending tens of thousands of dollars in needless attorney's fees, because if I had taken the proper steps, you would never wind up in court. There wouldn't be any probate proceedings necessary in Florida. That's a real mess. Oftentimes I've been involved in several of them. So for all those reasons, we've got an expert coming on. I'd like to know, have you taken appropriate steps to secure your estate, to take the necessary plans so that your heirs, whomever they might be, are properly prepared so that you don't have to waste funds on attorney's fees, which should be the 8th deadly sin. Thou shalt not spend attorney's fees needlessly. I'd like to hear from you. Email us, kl@kerrylutz.com. So Caryn Keppler, a fellow New Yorker, has been doing estates. She, prior to that, worked for the Internal Revenue Service and has done extensive litigation in surrogates courts. That's the court where probates are handled in New York State. And it is a really interesting area of the law and of legal practice. Caryn, hey, I'll bet you business is really booming now, isn't it?
Well, Kerry, yes, business is really booming. People are very, very concerned about their estates, and with good reason.
Yeah, well, the worst thing you could do to people you care about, it's bad enough when you pass on, okay? If you were close with your family or even not that close, there's going to be trauma involved. There's going to be a lot of grief, literally, and you don't want to add to that mess that's on their hands. And it's really so simple. I mean, estate planning perhaps might begin with a will, but there's a lot more involved. Like, I didn't even have a healthcare proxy. I didn't have a HIPAA release so that my kids could actually call the hospital and talk to the doctors. Fortunately, they had one at the hospital. You might want to have a thing called a DNR, a do not resuscitate order, because if you get to a certain point, you don't want them trying to prolong your life. All of these things, Caryn, I was ill prepared for, and it's not like I didn't know about it. It's just, I don't know, I wasn't in denial. I just was out of touch with it, I guess.
Well, I don't think, Kerry, that you're any different from a lot of people, unfortunately. One of my mentors used to say doing estate planning is about as pleasant as having a root canal without Novocaine. None of us like to think about our demise, but you are absolutely correct. It is very important to get your estates in order, both for during your life with respect to powers of attorney, healthcare proxies, and living wills, as well as for planning for potential disability, and as well as death. And we recommend that most people don't just do a will, that they also do a revocable trust for several reasons, including the fact that, yes, down in Florida, probate is awful, as it is up in New York. and we want to avoid it at all costs.
So power of attorney, it sounds rather ominous. In some ways, it really is the most important document that you can prepare, isn't it?
Yes, it is, because you appoint a person to make financial decisions for you, and it can be presently effective or spring into effect at sometime in the future. And it's really important because it can help you avoid having court intervention in the event that you do become incapacitated. If you have a proper power of attorney in effect, in most cases, you can avoid the appointment of a conservator or a guardian.
Right. And that means when you have those people appointed, that means money, that means court proceedings, and that means what could be really a needless financial expense if only you had done it before things happened. It's like so many things in the law, so many things in life. Where an ounce of prevention literally being worth tens of thousands of dollars worth of cure.
That is correct. And in addition, when you think about a conservatorship or a guardianship, you're talking about court intervention basically at every point of your life, because the courts will obviously or hopefully take into account that you maintain as many of your civil rights as you possibly can. But to the extent that a guardian is appointed to take over for you, to an extent, the guardian is going to be making all of those decisions with court intervention in many cases.
Right. And that means repeated trips back to the courthouse, and that means legal bills. Now, obviously, you're an attorney. That's how you earn your living. But no self-respecting attorney ever really wants to see their clients throwing out money for something that they really don't need to be spending money on.
Absolutely. And we don't want to see any of our clients losing more control of their life than they have to.
Exactly. Hey, one thing that was interesting that I noted here in your write-up is that 3 in 4 pet owners actually appointed a guardian for their pets. This was when I went to law school. And I actually did sit on that class where they taught law. Nobody ever thought of appointing a guardian for a pet.
That is correct. And it is now a real concern of many, many clients, of many of all ages and backgrounds. And what most states have done, including New York, have passed statutes that allow for the creation of what is called a pet trust, in which you designate someone to take care of your pet and provide money so that they can do so, including, vet visits, food, and eventually funeral or cremation plans. And the beauty of those pet trusts is that not only are you giving your pet to somebody that you trust, but you're also providing a stream of money that is available to take care of that pet. And we're seeing a lot of people doing that at this point.
And this reminds me of a really famous case. I'm sure you remember it. Leona Helmsley, wife of Harry Helmsley, real estate magnate in New York City. When she passed on, she left, I think, $10 million for her dog, and basically commanded her heirs to take care of it, or otherwise they wouldn't get the money. And I'll never forget the headline on the New York Post. There was a picture of Leona Helmsley and a picture of the dog, and it said, the headline was "Rich Bitch, and we mean the dog."
Yes, it's absolutely true. And by the way, the dog's name was Trouble, of all things. But but yes, she did leave an enormous several millions of dollars to Trouble, and directed her heirs to take care of the dog. And actually, one of the things that precipitated a change in the pet statutes in New York was the fact that she had left so many millions to her dog. And so now the courts in New York, at least, and I can't necessarily vouch for other states, have the ability to adjust that amount so that it is more appropriate amount to take care of the animal for the rest of its life.
Yeah, I heard they were feeding that dog caviar and Kobe beef steaks for dinner and all of these things. But yeah, people go a little crazy about this stuff. But providing for your pet after your demise, not such a crazy thing to do, really, for sure. You know, one thing I've seen, and I know I did it for myself once I had children, put in an estate plan, but eventually those children get bigger, things change. How often should you be revising your estate plan, in your opinion?
Don't just survive, thrive. The Financial Survival Network.
Lumina Gold, ticker symbol LUM on the Toronto Venture and LMGDF on the OTC, is yet another of legendary mining investor Ross Beatty's Lumina Group. It's advancing the largest primary gold deposit in Ecuador. The resource is estimated to contain 16.7 million ounces of gold and 2.2 billion pounds of copper. At just $7 US per ounce gold equivalent, it trades at an incredible 13% of its net present value. More good news is on the way with an updated PEA study expected in Q2 of 2020. It has unparalleled infrastructure. There's grid power to camp with plentiful, inexpensive hydropower available. It's close to 2 ports and is just 8 kilometers from a paved highway. Water is plentiful. It's at low elevation, and the closest community, which is very supportive of Lumina's effort, is just a 7-kilometer ride. With all this going for it, it's likely to follow the typical Ross Beatty formula, which means big returns to shareholders. Find out more and sign up for notifications at luminagold.com. That's Lumina, Lumina gold.com.
This is the Financial Survival Network, the information you need to thrive now more than ever.
Well, first of all, we offer a annual review to our clients here at Pierre O'Connor and Strauss, but at the very least, we say that an estate plan should be reviewed every time there is a major life change, whether that be marriage, birth of children or grandchildren, divorce, whatever it might be, as well as whenever there is a significant change in the law.
Right.
So we try to keep up with those things and get in touch with our clients so that they are always up to date and their estate plans work for them regardless of any change in circumstances or the law.
Okay, so let's just talk about what happens if you don't do any estate planning, because many of you out there really aren't familiar with the intestate statutes and how your estate gets handled. Because if you have any kind of funds, any kind of assets, and you don't plan for the day when you're not going to be around any longer, the state basically takes over and decides who gets what.
That is correct. And if you are married and you have children, you would be very much surprised to know that in almost every state, your spouse will not get 100% of your estate. It will be shared with children. And for instance, in New York, it's 1/3 to the spouse and 2/3 to the children. And if you have minor children, that presents further issues because the court would actually have to appoint somebody to handle their finances, a financial guardian, which is not necessarily that child's parent.
Right. That could cause all sorts of problems, especially later on down the road, when the children get older and the spouse was managing all the affairs and they're not happy with what he or she did. And then you have future litigation. I've seen it on a number of occasions, for sure. So one other thing. So with bank accounts, every state has a statute where you can assign a beneficiary to your account. So if you die, the account automatically goes to that person or persons. And yet so many of you out there don't take advantage of it. And then the asset, brokerage account, whatever, becomes part of the estate and winds up going into probate. This is a real problem of people not thinking of this, isn't it?
Well, we actually find this is a problem, and it's actually can be more of a problem if people actually do put a beneficiary on their brokerage and banking accounts, because that means that they're not they may be disinheriting other people that they would want to be benefiting in their estate, as well as creating tax issues to the extent that there is estate tax or inheritance tax due on their estates, and their what is called their probate estate, their assets passing under their will, is not sufficient to pay the tax. And that means that you basically have to go after the beneficiary of the banking or brokerage account. But we also recommend for probably 90 to 100% of our clients that they steer clear of just doing a will in any event. That in most cases, they should be doing a revocable trust plan and transferring their assets into that revocable trust prior to their demise to avoid probate and to actually have a seamless transfer of their estates upon their death with minimal court intervention and minimal legal fees.
Mm-hmm. Interesting. Yeah, different lawyers have different takes. I guess a lot of it depends upon the size of your estate, your potential estate, and the heirs involved. If you just have one person who you're going to be leaving everything to, and it's a simple estate, then that might be the way to go.
It may be the way to go, but certainly not if you have substantial assets, if you own real property or tangible personal property in more than one state, because you want to avoid having multiple probates in addition to that one. When I see simple wills, it is generally for young couples who do not have any substantial assets and are really just looking to name guardians for their minor children.
Right. I gotcha. And what about with real estate and the way that it's held in title as far as passing that down to heirs? I mean, husband and wife, joint title, joint ownership of the right of survivorship usually, but it gets more complicated than that, doesn't it?
Oh, absolutely. It gets more complicated. And it especially gets more complicated if you're in a community property jurisdiction. But in many instances, it may not be the right thing to have your surviving spouse just simply inherit your real property. We're finding more and more that we have couples who are in second marriages, and they each have children from their first marriage. And by leaving everything in joint accounts or holding real estate or other residential property jointly, they may actually be disinheriting their children from a prior marriage. And that is not something they necessarily want to be doing.
Right. So all these things. So if you're going to get married or you've gotten married recently, right, or you're thinking about it, you really... along with your prenup, assuming you're going to get one of those, you really need to be considering these issues before you tie the knot, shouldn't you?
Absolutely. And in addition to straightening out all of the property issues while you still like each other, presumably, you are also, it's also a wonderful learning experience for any couple, young or old, because it focuses on the financial and pseudo-contractual rights of marriage. And you learn a lot about your future spouse by going through the process.
Yeah, that's for sure. And many a betrothal has been liquidated due to the inability of the parties to come to an agreement on a prenup. Do you recommend everybody do a prenup at this point in time?
Yeah, well, if you have any property or you have any potential large inheritance, or you are in or going into a profession where you expect to be accumulating large amounts of property, absolutely, you should be considering a prenup.
Yeah, I couldn't agree with you more. Hey, people want to find out more about what you're doing, get some advice. How's the best place to find you?
Best place to find us is at pierrolaw.com. That's PIERROLAW.com.
All right. Hey, have you got any estate questions anything else for Caryn, just send us an email. I'll forward them off to her, kl@kerrylutz.com. Make sure you go to the site, financialsurvivalnetwork.com, and sign up for your free newsletter. Caryn, a pleasure. Thank you so much for coming on. The information you gave us was incredibly valuable, and I think will help many people out there.
Thanks for having me, Kerry.
Thanks for listening to Kerry Lutz's Financial Survival Network, your solution to today's trying times. For the latest, go to financialsurvivalnetwork.com. Financial Survival Network, now more than ever.